So I'm really excited today. We have Adam Sherwin, who I think I've known now for, I want to say like 7 years or 6.5 years, something like that. He is an attorney who focuses on real estate litigation, and I've mostly, connected with Adam around tenant-landlord law. I met him through an organization, Mass Landlords, a number of years ago. So I'm very excited to have Adam here today. Adam, thanks for being with us. I know a lot of the listeners here are landlords in Cambridge, Somerville, Medford, Belmont, Watertown, all around the Boston area, Malden. And so I just really wanted to do like a deep dive and kind of go over a lot of the questions and concerns and things that I know landlords are always asking me. And, I give them my real estate agent perspective, but it's a little different from the legal side of things. So I think the first thing I just wanted to kind of start with one that comes up all the time, which is security deposits. I feel like a huge chunk of, especially first time landlords, they buy a property, they know nothing about it, they have no idea. Can you maybe like share a little bit? Let's say like I just bought my first multifamily, I know nothing about it. Can you kind of share from the legal side what are sort of the key pieces that I should be thinking about if I'm a landlord around security deposits in Massachusetts?
Well, thanks for having me. If we want to cover all security deposits, we may need to do more than just a podcast because it's a loaded question. If anyone takes a look at the security deposit law, you'll see that it's about easily 15, 20 pages. It's incredibly complicated. It's got a lot of nuances, and no one can really, in my opinion, few people could really ever completely comply with that. So my kind of first piece of advice about taking a security deposit is don't take a security deposit. I think for most landlords, they don't, most landlords, especially smaller ones, really aren't going to be set up to follow all the requirements for a security deposit. So that's kind of the first piece of advice is just don't take it in the first place. What I usually tell landlords is if you want an alternative to a security deposit, you can build a security deposit into your rent. So let's say you're renting your apartment for $1,000 a month and you wanted a security deposit, bump your rent up to 1,050 or whatever. Take that little bit of difference and hold on to it and put it in your own account. And then at the end of the tenancy, you have your own security deposit, and you don't have to go through all the many different requirements that come up.
That makes
So that's
sense.
kind of a yeah.
I was just gonna. So I think So I often give the same advice to new landlords, and I think the first pushback is I need a security deposit because it protects me, and I want the formal security deposit. And so I think a lot of landlords don't understand what the actual risk is. Can you kind of talk a little bit about like, well, what could go wrong? I guess like like if you don't follow these rules, what could happen? You know?
So during the tenancy itself, while the tenant's in the property, if you make a mistake with the security deposit, the tenant can request it back at any time. And the law says that you have to immediately return it. What does immediately mean? Nobody knows. We don't know exactly how long it is. So my concern, some landlords take the position, well, I can just return it if someone asks. Well, if you're overseas, let's say you're on a trip, let's say you're away, let's say you're dealing with a family matter and you're not immediately by your bank account. If you take a couple of days, is that immediate? Nobody knows, and we're not going to know until there's going to be a test case. Some landlord will be the model test case, and we're going to find out. And
Hmm.
no one wants to be that test case. So during the tenancy itself, the tenant raises an issue with non-compliance. You can immediately return it, and that's exactly what a landlord should do in such a case. The holy grail of security deposit violations is holding on to a deposit over 30 days after the tenancy is over. So the tenancy ends, you have 30 days to account for the deposit, and return it if you have to return it. You can keep the deposit if there's owed rent, and you can keep it if there are legitimate damages to the apartment and you follow the paperwork for that. But if you have a deposit and it has to go back to the tenant, you have a 30 days to return it. It's not returned within 30 days. It's treble damages, attorney fees, and costs. So it can get
It's up to
incredibly
three
expensive.
times, right?
3 times. So a $2,000 security deposit could easily become a $10,000 judgment in the blink of an eye
And so to
for
be
not
clear,
doing
that's
that.
9, 10,000 plus the security deposit.
So it would the $2,000 security deposit would be 3 times 2, so $6,000.
Plus the
It would
two.
be costs. It would be the court costs if it goes to that, as well as attorney fees if the other side has an attorney to pursue.
Oh, so you also have to pay for the attorney fees. I didn't even realize that. Okay, so it could easily be over $10,000 in that example.
Yeah, that's what I gave him. That was just a
Yeah,
hypothetical too.
yeah,
It
no,
may not in some cases too, but you know, travel damages, costs, and attorney fees, but it adds up very quickly.
got it. Okay. And to shift gears a little bit here, this is another like common question that comes up, which is like, okay, I signed a new lease for 12 months for September 1st. October 1st rolls around, tenant got a new job, couple broke up, they're leaving, they want to break the lease. And most owners, I'd say, are like, look, I'm going to work with them. As soon as I find a replacement tenant, we'll be good to go. But I've had some landlords come to me and say, Sage, why don't I just make them pay rent for the next 11 months? And I think there are some legal things around this that I don't fully understand. They have some obligation, is that right, in terms of trying to find a replacement? Or how does that work in a situation like that? Or what, anything you can share on that?
Yeah, so it goes back to basic contract law. It's referred to as mitigation of damages. So it's a legal concept that if someone breaks a contract, the person who's suffering the breach, who's being harmed by that, but the other side breaks it, you can't kind of just, collect waste, so to speak. You can't just kind of sit in your hands and let it accumulate. You have to do something to recoup that damage and make a good faith effort to do that. That applies for generally all contracts. So not just for residential, but for other service contracts and good contracts and all that. If someone breaks a contract with you, you're supposed to kind of take some sort of action on your own right. So if you're the landlord, you need to be re-renting it as quickly as possible. You want to be out there and taking as many efforts, using a realtor like yourself,
Mhm.
posting it, showing it, and doing all that you can as quickly as possible.
And as a landlord, you can. I've had situations where a landlord comes to me and says, "Okay, they broke it, but now it's the busy season. So I'm going to jack up rent another $1,000 for the existing." You can't do that, right? Like that's not kosher, right? Or is that? Or can you do something like that in the middle of a broken lease?
I think what I would say about that is that I think at the end, if you're doing it and you find someone, like if that's really the market rent, if it tends to be higher, go for it. So
Okay.
I would say take it too. What you can't do, and I think what you're kind of alluding to, is you can't jack it up so reasonably high that no one's going to want to rent it, so that you can come back later and say that you couldn't get it rented. There's also a practical piece of this too, and this kind of leads into what I think is a little more practical component of this matter, is that you as the landlord could go after that tenant for their damages. You could try to sue them and all that. Collecting that money is going to be against a tenant is very, very difficult to do. It's very difficult to go after any tenant for owed money. So the likelihood is that the landlord probably isn't going to recoup that money anyway. So their best bet is to get it re-rented as quickly as possible. So if a market rate happens to be higher and you can get that, I say go for it. But if not, be reasonable and get what you can as quickly as possible.
That makes a lot of sense. And to kind of step back, I actually always wanted to ask this, but I never have had the chance with you, which is like, can you just like just step way back here? How did you get into tenant landlord law? You passed the bar. I'm guessing you could have gone a lot of different directions. Did you know when you went to law school this is the direction? Can you like? I'm curious like how you ended here specifically.
Yeah, I've always really enjoyed property law. I like law that kind of affects people on a daily basis. That's what I really enjoy about my work is I deal with issues that happen to people on a regular basis. Most of us, fortunately, are not going to be charged with a crime. We're not going to be dealing with a constitutional issue, but property affects every one of us, whether it's leasing, whether it's buying a property. There's a theory out there that says that land use disputes are the single biggest, legal disputes of all people.
Really?
All of us, yeah, all of us at some point will go through some sort of land use dispute, and I agree with that. I think that's actually absolutely correct. So I enjoy law that affects people on a real basis. My dad's also a landlord, so I saw it growing up from his perspective. We rented growing up. He still rents to this day, so I learned quite a bit from him. My first job actually was a little bit on the other end. I did foreclosure defense when I started out. I came out in 2010 when the market was terrible. It was terrible for everyone. The financial crisis was still going on, and foreclosures were going on left and right. It was a big area, and a lot of foreclosures actually end up in the eviction process. So
Mhm.
if you have a foreclosure and there's someone living there, you have to evict that person. It has to go through an eviction. The rules tend to be a little bit different. The law is certainly much different, but it's the same process. So that's in a way how I fell into that when I was doing foreclosure work. I was dealing with quite a bit of evictions on those matters.
So when you say you started with foreclosure work, who were you representing, and was it on both sides? You know, so I'm guessing so when you're talking foreclosure, you're talking about someone who lives in like a single family house, and then the bank is trying to sell the property, and they need to get those people out. And were you representing the people who were being evicted then primarily, or how did that work?
Yeah, I was representing mostly for former homeowners against banks in those proceedings. I have been on the other side. I actually have represented people who bought foreclosed homes, so I have kind of perspective on both sides. But my practice back then was more for the homeowner side, and I still do those cases. I don't do as many as I used to, but I still do
I'd be,
foreclosure work.
you know, I don't know that much about foreclosures, but I'd be curious to know like how if someone's in a home and the bank is trying to take things back, like what was your success rate? And like what were you usually trying to get out of it? Was it like, no, we're gonna stay in here long term, or was it like, no, we want some kind of financial settlement? Like what was I guess the end game and like what was the success rate like in those kind of scenarios? I'm just curious.
Yeah, the goal is always getting the home back. At the
Okay.
end of the day, I mean, there's some unscrupulous, people in that field who your goal is just to stall it as long as possible, which was never really my interest. My goal was to see a permanent solution where the person got their home back, a home back with an affordable loan. I actually think I did pretty well with it. I had quite a few success stories. A lot of times, very creative success stories. We've been able to find times where I've been able to work with someone to help buy a home back through the support of other family, or get a modification of a loan and a rescission of a foreclosure and whatnot. Some cases there were some cash settlements and arrangements for people just to leave on their own terms with some additional time. So it's kind of created, a number of different resolutions. For the most part, I think, I had fairly good success. They were never easy cases, but I did enjoy it, and I still do. I still do enjoy that work.
That's very cool. And to go back to sort of the tenant landlord stuff, around this is I'm just going through. I just there's certain questions that I just seem to get over and over.
Sure, sure.
Another one is around like the idea of like rent increases. You know, I think it's definitely a lot of landlords I work with in Cambridge that were living in Cambridge during rent control, and so a lot of people are asking, you know, can I just increase rent as much as I want? Are there ever limitations? Are there ever scenarios where I can't, where in some way there's a limit to how much rent can be increased? And I also get this question a lot from tenants too. You know, like I moved into this place for 25. A good example is during COVID. When COVID happened, average rents in the areas I was working went down about $500, and in some cases as much as like $1,000 a month. They signed a lease for a year. Then the COVID situation improved. A lot of those landlords were losing money, and then the market supported a rent increase, basically back to the median, which was up, you know, 500,000 bucks depending on the situation. So, is there any limitations under any circumstance in Massachusetts in terms of rent increases? Just curious about that.
Yeah, so Massachusetts, we don't have rent control, thankfully. We don't have any requirements on what you can increase on rent. So landlord's free to increase as much as they like to. The two kind of restrictions on that is you can't discriminate, so you can't raise someone's rent for one of the protected classes. If landlord ever wants to know the protected classes, I couldn't even tell you offhand. I tell people just go on the website and just Google it. You'll see the 15 classes, protected classes, and it's often things that you may not necessarily think of, but you can't do that purposely to discriminate against someone. You also can't retaliate against a tenant. So if a tenant's complaining to you about a problem in the apartment, you can't raise their rent as a way of punishing them. So those are kind of the two restrictions on that. The more practical piece about raising rent is I often tell landlords is it's better to do yearly increases than it is to jump it up all at once. And you're going to know this better than I do. But for most landlords, you do need to have a cost of living increase. You do have to do modest increases. What I've seen is if a landlord doesn't do that, but one year does a huge jack, and they jump it up, like five, six, $700 in one year, that causes all sorts of pushback from tenants. So you're much better off doing it on a regular basis and just being upfront with the tenants about that. I
Yeah,
think, and I think you have a better perspective than I do on that, but I think that avoids a lot of the problems of waiting for one, big increase later on.
I think that's great advice. I generally advise exactly that: small increases each year, or Just if you have a sense, there are certain areas where turnover tends to be pretty high. Just wait on turnover and make the increase then. If people are
Yeah,
leaving
that's a good point.
1, 2, 3 years, just do the increase then to market.
Yeah.
What about like so? This is another really big issue, which is around so two part question about pets. The first is the idea about pet fees. I remember when I started in real estate, I was under the impression that pet fees were illegal. Um, and then I remember there was some case that came down where it sounded like maybe they were totally legal, maybe there was some gray area. And one thing that kind of also always kind of threw me off with this whole thing with pet fees is I remember even in the beginning when I started and I was told it was illegal by a number of people, I would go into those big luxury buildings and they always had pet fees and they were very transparent. It was in there. So I'm wondering if you can speak a bit to this because I've always kind of been thrown on like what the actual rule is there.
Yeah, so for pet fees, it was unclear would be the better way to say it. There
Okay.
was a big case that came out years ago that clarified it, but for a while, pet fees, it was unclear. And the reason a lot of us on the landlord side were very hesitant about that is that Mass is very restrictive about what you can charge up front. So it's
Mhm.
very tight about that. You can only take a first, last security and a fee for replacing a key lock. So we were very hesitant to tell landlords that you could include a pat rat. We were worried about them coming back and saying that that was an extra fee. The larger companies, I know that they were doing that, and a lot of them, they have their own protocols and procedures. And I believe it was actually one of those large property management companies. That was what the case was against. It was
Oh, it
against them.
was. I didn't know that.
Yeah, and
Interesting.
they succeeded. That it was their clause, and they convinced the court that it was okay. So what we know now, based on that decision, I believe it's the Fleming decision. I think it was a couple of years ago. But the decision that came down said that pet rent is okay. That if you want to charge an additional fee for a pet each month, you're okay with doing that. You can't charge an extra security deposit. You can't charge a higher security deposit on account of a pet. But if you want to include, an extra fee for the pet, you can certainly do that. I always remind landlords don't do that for an emotional support animal or a service animal because that probably wouldn't be considered a pet. But for any other pet, the law says that that's okay.
Got it. So it's okay to write that into a lease. I mean, one of my concerns about what I've always told clients to do, just to kind of be extra safe, is to just, if you have a pet, you're going to charge an extra $100, just increase the rent that amount and just say you're approving that one pet. Just because, to your point, my thought is what happens if someone moves in with a pet and then all of a sudden they bring emotional support animal papers, it just gets kind of complicated then. I feel I don't know how you'd handle a situation like that, but that kind of leads me to the other question, which is separate from the pet fees. I think a lot of landlords get tripped up around emotional support animals versus just like a regular pet versus a service animal. Can you like quickly break down for landlords like what, because I swear like I've had this conversation 100 times, it just happens all the time, like what is the difference between uh, each of those?
Yeah, it's a hot area. It's a huge area of discrimination complaints. I've seen it in my own practice, and across the board, it's become a very big issue in the last, I'd say, 5 years or so. It's gotten very big. So, a service animal is an animal that's specifically trained for a task. So, think of a seeing eye dog, I guess seeing eye dog would be, or like a dog that assists someone with walking. That's a dog that's trained for that. So, it's specifically trained for that task. If someone comes to you with a service animal, in my mind, from the landlord, you've hit the lottery because that's going to be the most trained, most respectful animal you could ever imagine. If you see how much money and time goes into training a service animal, it's great. I think it's great for a landlord because that's going to be perfect animal to have in the apartment. Emotional support animal is not trained in any way. It's just a pet that a professional, a doctor, a therapist, or a licensed worker has said that they need for some sort of disability. So general rule is if someone comes to you and they do have a disability and they can verify that, that's what's called making a reasonable accommodation request. They're asking, would you allow this animal based on my condition? My general rule of thumb for all landlords is if it's a household pet, if it's a dog or cat, most of the time you're going to have to allow that. So even if you generally don't allow pets altogether, you're going to have to make an exception if they can prove that they have that they have documentation that they need this emotional support animal. I
And that
think
would
the
be like
best advice. I'm sorry.
The documentation would be like a letter from does it have to be are there strict rules on what counts? Because I don't know that much about it, to be honest, but
Yeah.
I've Googled and heard from just stories from people really that like you maybe just go to a website and print them out. Like, is there any sort of rules or regulations around this, or is it kind of like if you can bring a note, that's really the end of the conversation, or you know?
It should be a legitimate
Okay.
documentation from a professional. So you can buy it online. You can buy ESA vests on Amazon or fake certificates. It's not hard to find it, but it should for a landlord you can certainly ask for verification, and you can certainly verify. If someone gives you a doctor's note, you can certainly call and make sure that that person's legitimate.
Okay.
The kind of the advice I give any landlord, what I see landlords get really tripped up about is someone comes to them about that, and the landlord gets caught off guard and says very quickly, "I don't allow pets," or "I can't do that." That's always the worst thing you can do. The
Hmm.
best thing for all landlords, if any tenant or prospective tenant comes to you about some sort of accommodation, I think the magic word should always be, "Let me review that and get back to you." Because that
Hmm.
gives the landlord a chance to look at the law, to speak to a professional, speak to an attorney, and gives them time to process it. So that's how I would handle any time one of those. Let me think about it, and let me review it, and I'll get back to you as quickly as possible. That way, you're not giving a decision on the spot. You have a chance to kind of review the matter on your own.
That makes sense. Okay, let me go. So the security deposit thing, something just popped in my head, and this is another thing that I feel like has always been a gray area. That I had a question I think last week about this, which is, okay, I understand all these rules apply to security deposit. What about last month's rent? And this question I usually get about last month's rent specifically is number one, can I just put in my own personal bank account or the account that I just used? Does it need to go in a separate? Does it need to go in the escrow account, the W-9 account, set another W-9 account? Does it need to generate interest? Do I need to pay that interest to tenants, or can I just simply take that money and treat it like rental income and do what I wish with it? What is the rule around that? That's like a very common one I get.
Yeah, so last month's rent is your rent, so you can do whatever. You can spend it, you can do whatever you want with it. The caveat behind it is the law does say you're supposed to pay interest on it. And this is one of those areas where the law is still a little unclear. We don't exactly know yet. Does that interest mean interest if you actually get the interest, or if you spend it and there is no deposit, do you still have to pay interest on money that you don't have? And the
Mm,
law is a little bit unclear about that. You don't have to keep it in an escrow account. And I wouldn't keep it in an escrow account. It's your money. But I would put it into a savings account, and I would give interest on a yearly basis. That's my advice. Put it in your own savings so you have a record of what interest it accumulates, and then give the tenant that interest every year. It's peanuts. It's going to be a couple cents on the dollar. It's almost it's so the law is, in my opinion, is a little overkill. In many cases, we're fighting over 2 cents on the dollar, if that. But
yeah.
it's the state we live in. So that's my advice. Last month's rent, put it into a separate account on a yearly basis. Put it on your calendar, and then give them the interest. And that's the best way to stay out of trouble.
Write a check for 24 cents or whatever it is. Yeah.
Yeah.
Okay. That's interesting. And so, okay, this is another, I'd really curious to hear your thoughts around this, which is the topic of squatters. And I haven't experienced, or I haven't spoken with a client who's experienced this that much, but I have had a few stories over the years. Last year, there was a situation where basically what happened, I'll keep it brief, but basically, uh, a client of mine rented to a Section 8 tenant, very nice older woman. And this is to the best of my knowledge, so we're not going to name names or anything, of course, but basically she passed away, and then no one ever communicated with the landlord, and about a month later, it was determined that that person's, I think it was son or some kind of person who was connected to this person, moved in and brought in a bunch of people, and this was a little, I think, it was a two-bedroom apartment, and they had, I want to say, 8, 9 people. And so it just became a very stressful thing. It was a very expensive thing. Ultimately, the place was totally destroyed, needed to be gut renovated. It's kind of how things ended. And eventually, the people did leave. But I'm curious, in a situation like that, what advice would you give to landlords? Um,
So,
no, you're good. What advice would you give to landlords to, number one, prevent something like this from happening? Because it kind of felt like a fluke thing where I was like, if I don't know that anyone could really prevent this, and then number two, if it does happen to you, what's the best way to approach it right out of the gate to kind of get into a better situation for both the squatters and for yourself?
Yeah, so I mean, I think the first rule is always know who's living in your property. I think this becomes an issue. Years ago, I rented an apartment where it was a couple of us living there, and it was treated very informally. With one roommate would come in, another room would come out, and the landlord had a very hands-off policy. That can be an issue because, very easily you lose track of who's living there. So
Hmm.
you should always have a written agreement that should always be amended if someone new is coming in. It's
Hmm.
perfectly fine to change it. It's perfectly fine to let people come in and out if you know them and you're okay with them, but you want written proof of that. You don't want a situation where, very quickly you don't know who's living in your own property. And believe it or not, that happens a lot more than I think some people might imagine.
Hmm.
In terms of trespassers, if you have people there who are living there that you don't know about that, what you could always do is you could always try the local police first off. You can reach out to them. Most of the time, they're not going to get involved. They're going to say it's more of a civil matter.
That's
But I
fair.
don't think it's a bad idea to make a call. Occasionally, you might get someone who it rises to the point where they're willing to go over and speak with them. But you could always try that. If they're not going to get involved, then you do need some sort of court action against the trespassers. There are ways to expedite that. It could be much quicker than an eviction. So if it's a pure trespasser, there are ways to get it before the court much sooner than a normal eviction. But kind
Interesting.
of the quick and easy answer is it will require some sort of court action.
So it sounds like they should get someone like you involved in a situation like this. Like maybe try initially to see if you can sort it out. Maybe I don't know yourself with the police, or maybe you can talk with the people. But if it looks like it's not working, get an attorney involved. Sounds like is the best answer there.
Yeah, that's the easy way too. And I have been brought those successfully, so it is something that definitely can be done.
And okay, and that actually triggers the as we got talking, the idea of like keeping track of who's living there and not actually triggered something else, which is another common thing, which is like I feel like there's this gray line of like, okay, at what point is someone a visitor or a friend coming over? And at what point is someone basically another tenant? And so like some common examples that I can think of is a situation where, you know, it's a small studio and then the person doesn't communicate anything, and then all of a sudden they have their partner, and maybe they're dating, and maybe they're coming over once a week, twice a week. Uh, they're spending 4 nights a week, and then all of a sudden maybe the owner notices the water bill's doubled, or notices there's disturbances with neighbors, not because of the initial person, but because of this new person. I can think of a lot of times where this happens, and I think landlords often ask me, well, like, what is the line between visitor or not? Should I write something in the lease? How do I approach this? Like, if this starts happening, like, do you have any guidance there? Because this is kind of a thing that comes up. And then a lot of times, like you said, like, landlords have no idea. And then what happens is when we're going to find a new tenant because the lease isn't being renewed or the tenants have just moved on, you come in and you're like, wait, there's another 5 people. Who are all these people? That happens too.
Yeah, yeah,
Yeah.
yeah. There's no magic. I don't have a great answer on that. Really, I mean, fortunately, when you're renting, you are putting a considerable amount of trust in the hands of someone else, and if they let someone in there, they allow someone in there. They are, any place is generally allowed to have guests of some sort. So it's not always a perfectly clear line about who's in there or not. I have seen leases that do have that say that you're limited to a certain number of days on there. I mean, you could do that, I suppose, but the end of the day, I don't have a great answer for it. I have had cases where there have been unauthorized visitors. It can be hard to prove. It can be hard to show convince the judge that this person's here on a number of occasions. I had a client that put up surveillance cameras, and we could show particular people coming in at 2, 3 in the morning every day, which
Hmm.
I thought was good proof. But at the end of the day, it's going to be whatever the court really believes.
Got it. No, that makes sense. Yeah, I think like a lot of things, like one thing I've learned over the years is that like a lot of this comes down to just trying to work with the tenant. Tenants are people, landlords are people. There are good tenants, good landlords, bad tenants, bad landlords, and if you can just be reasonable and work with a reasonable person, most of the time you can work out almost anything. And starting there usually goes a long way. What do you think is some of the least known issues that land, and I know we probably covered some of them already, maybe, but like some of the least known issues that like you tell a landlord, like you talk to landlords every day, like, and they're surprised to hear, like, wait, that's a thing in Massachusetts? I never heard about this. That you think they'd be surprised to know about. Can you share like a couple?
I mean, I think the emotional support animals are a big one. A lot of people don't know about that. Security deposits, that comes
Hmm.
up quite a bit. I think starting an eviction, a lot of people, try. A lot of times I've seen landlords try to do their own eviction notices, which if it's not followed properly, it's going to be a huge, huge setback in the case. I've seen quite a few evictions get dismissed because the notice isn't correct or the court paperwork isn't done correct. So I think you have to be certain what you're doing, or you want to work with a professional who can handle it.
That makes sense. Yeah, I feel like if you have to go through an eviction, it's critical you work with an attorney. You don't try and do that kind of thing yourself. I know, like, I was on your website, and one thing you mentioned was like things around like boundary disputes. I thought that was actually really interesting.
Yeah,
I helped someone buy a two-family in Cambridge last year, and I think like within like a day of closing or something, his neighbor was knocking on the door, or I forget how he reached out somehow and was saying, all these years, like there's been this little piece of land that's been on my property, and I want to get a curb cut, but I need a piece of land back. And if you don't give it, I think he actually was an attorney. He was kind of threatening him right away. Um, and I've realized in the last couple of years, I've had a handful of these situations where and it usually is around like a fence or parking. It seems to be the one that I keep running into.
yeah.
Um, do you have any advice for someone who's maybe recently purchased a property? I feel like oftentimes it comes up right after the purchase where like the neighbor is like, okay, this has been on my mind. Maybe they didn't go for it with the current neighbor, or they wanted to make nice because they knew each other, but now someone new. And it seems like I've noticed this pattern over and over again where that's when it seems to start. So like if a neighbor comes to you, you buy a new house, whether a single family, whatever, and then something comes up, like do you have any advice on like how do you even like where do you begin,
Yeah, I mean, you could always see if your title insurance will cover the matter. In many cases, it may not, but you could always try that. So when you purchase a home, the bank, usually the lender has title insurance, but you have the option of buying your own insurance, which you always should do at a minimum in case an issue comes up, and it may cover a dispute like that. So I would start with the title insurance. If they're not going to get involved, usually resolving a boundary dispute, usually you're going to need some sort of survey or plot plan. So that's kind of the starting point, would be getting a professional, find out where exactly the boundary is. That doesn't always end the issue, because there is law that's referred to as adverse possession, where if somebody uses property for 20 years in a certain manner, they actually become the owner of the property. It's meant to kind of resolve disputes like that. So if part of the driveway or fence or yard is used, it's possible that they could have taken it over. Those are very fact intensive cases. They really depend on the details. And yeah, as you said, it almost always comes up around a fence or a yard or driveway of some sort. What I've learned from doing boundary disputes is that boundary disputes very often are not just about boundaries. They get very emotional. They get people are upset about property, as I'm sure you've seen in your practice. So that's one thing to keep in mind. I've seen huge contentious matters over a very small
Slivers of
amount
land,
of
inches.
property. Yeah, inches. And I mean, sometimes it's a little ridiculous, but in other cases, especially here in Boston, in the greater Boston area, we're packed in together where every bit of space counts. So even a small amount of property can make a difference to someone.
And around this, something that I often get asked when I'm working often with buyer clients is like around like boundaries, around like fences or stone walls. Like one of the common questions I get is like, what happens when there's a stone wall and it's on both, it's on the line, right? So it's shared. Who does it belong to? If there's an issue and it needs to be repaired, what is the answer? You need to work together and figure it out. Is it you work on your side, and because it doesn't really work that way, right? Like how do you? Any advice for these kind of scenarios where there's like um, a shared fence, a shared stone wall, something like this?
Yeah, I don't recall offhand. I haven't had that come up in a while. Usually it's on one side. Usually it's pretty clear it's on one side. So, but if it's straight down the middle, I don't know. I think at one point I remember I looked into that. It really kind of came down to who put it up in the first place.
Oh,
Is kind of
interesting.
one consideration. But that's a tough one. I haven't had it come up. You could always talk to your local building department. Sometimes they'll have ideas about who it responds to. But offhand, I don't know exactly the law that would resolve that.
Okay, no, that's interesting. I think one of the other things is around. You've worked with a lot of landlords now. You've probably what, thousands, many hundreds at a minimum.
Yeah.
Um, you've probably seen like the really good, the really bad, and the ugly. Like I think one of the things that I really enjoy is like because I meet so many people, I get to see here's someone who's doing it right. You know what I mean? Like wow, they really have a great. They've created their own system through experience, through blood, sweat, and tears. And I feel like that's one of the advantages of what we do is you get to all the reps of seeing the wide range, and you see people who aren't doing it well, and people who are doing
Yeah.
it. What are a couple like lessons that you learned from clients that are like, wow, that's really smart, or like that's a good way of thinking, or like I really like the way you set this thing up. As a landlord or property owner, could be about anything. Just curious.
Yeah, I mean, my rule, what I've always found is that a good landlord, one thing that always correlates with a good landlord is good record keeping. So
Mm,
if a landlord's on top of things, they're going to have copies of everything that pertains to the tenancy. So a copy of a lease, a copy of the amendment, a copy of any work that's been done, good logs, good rent papers. Just the opposite is true. A very shady landlord, doesn't have that. The number who have had leases and they don't have a signed copy of the lease or it's lost, or they don't have paperwork, or they claim that there's a deposit and they don't have any records on that. My mind, that's a sign of a landlord that's on shaky ground. Doesn't mean that they're a bad person, but it certainly means that that's a very big red flag. I always have a rule of thumb anytime that a potential client calls me. I always require a potential client to actually send me something for the case, even if it's just sending me a copy of their deed or a copy of their lease. Always require that they email that to me first, because as a practical matter, I want to test that person is on track of things. Will they respond? Will they get what I need first? But do they have the records in the first place? Can they show that to me? If that's what I found over the years is that a landlord who doesn't have that, who doesn't have the paperwork in order, that's usually a telltale sign that they're not on top of things as being a landlord.
that makes sense. That's really interesting. And I know we've talked a lot from a landlord's perspective, but I wanted to shift gears a little bit from the tenant's perspective because I've had situations um, where a landlord is not doing the right thing. You know, bottom line, they're not following the law. They're not being responsive. If you're a tenant in a situation and things really are not, going the way that it should, I'm thinking about really serious things like, for example, like a sewer pipe is bursting and there's sewage in the basement, and you're calling the landlord for a month and nothing's happening. Very serious issues. Like, what advice would you give to a tenant that's going through something where they're trying to be reasonable. They're reaching out to the landlord. They're getting nowhere, or they're getting hostility. What advice would you give to a tenant in a situation like that um, to make sure that they're protected? What's the best way to handle something like that, like something severe?
Those matters almost always concern like a poor condition in the apartment. The landlord's not taking care of some matter. The best thing to do is to contact the agency that handles it, the local agency. In Boston, it's Inspectional Services. In some towns like Malden or Medford, there's a board of health that's responsible. You can call City Hall and find that out. But you can file a report with any of them, and they will come in and inspect the property and issue a citation to the landlord. And 9 times out of 10, that will get the problem resolved quicker than anything else that could be done. And as we talked about before, there's a law on retaliation. The landlord can't punish you for doing that. So if you file it, they can't come back and evict you or raise your rent, even if the complaint is not legit. So even if, let's say, you complain about heat and it turns out there is no issue, the landlord still can't punish you because of that. So the idea is to encourage tenants to reach out to the appropriate people who handle those matters.
That makes sense. That makes sense. That's really interesting. Um, that's really good. I mean, trying to think if there's anything else. I feel like I've been rapid fire here with all my questions. There's been so many over all these years that have been building up in my head, and you've like answered them all so well and so thoroughly. No, this has been really great. Yeah, I mean, I think I'm good here. Is there anything? Well, first of all, why don't you share if anyone listening wants to reach you and has any questions, they have any, real estate boundary disputes or tenant landlord issues, or are there other areas in which they could reach out to you as well? But maybe you can share your contact details as well.
Yeah, I can share my contact. I handle just generally all, most real estate disputes. I can always give a referral if it's something I don't handle. But I generally landlord tenant, boundary disputes, zoning matters, contract disputes, and stuff of that sort.
Okay, cool. Do you want to just give your phone number just so people know,
Yeah,
or email, whatever's best? Yeah.
yeah, it's Adam at sherwinlawfirm.com. And my phone number is 617-336-3236. I'm also encourage listeners definitely check out Sage's materials. I found them very, very useful. He puts out a lot of very, very good informative stuff, which I've learned a lot about. So if
Oh,
you
thanks,
want to
Adam. I
keep an eye on
appreciate
the
it.
market, definitely check it out.
Thank you, Adam. Well, thanks so much for your time. I really appreciate it. And yeah, until next time.
All right, thanks so much for having me. Take care, everyone.
All right, take care.
Bye.